The broadcast is now starting. All attendees are in listen-only mode.
Hey there, everyone. This is Blake. We're probably going to just wait another minute or two to begin, let a couple more people roll in. Thanks for joining us today. Hopefully this will be informative and give you guys all a good idea about the OP and some immigrant options for athletes as well. So let's hang on another minute or two here, and then we'll get started. One thing maybe to mention real quick, last Friday, June 15th, basically Obama came up with this big press release regarding deferred action, which is really big news, of course, for the immigration community. We're going to be doing an upcoming webinar on deferred action. It's going to touch upon the qualifications required for someone to really qualify and be able to apply for deferred action, the documentation that should be prepared and submitted, whether that's to USCIS or to ICE if someone's already in removal proceedings or custody, the potential benefits of the programs, and also potential concerns, which we're not totally sure how it's going to be addressed by USCIS or ICE yet. They're supposed to still come out with some further guidance on how the actual deferred action program is going to be implemented, what kind of forms are going to be used, where to file. All the procedures are still yet to come, but I'd say in the next week or two, look out for a webinar from us touching upon all the good stuff about deferred action. So just to introduce myself, my name is Blake Miller. I'm an associate attorney with Woolsdorf here. We deal with a lot of entertainment and athlete visas, so a lot of those discussing today we file all the time. U.S. immigration for athletes is really exciting. They're usually fun cases, but they can be very challenging. There's a lot of funky subcategories within the O and P categories. Each case often presents its own unique twists and turns. Each sport is very different. You know, you have swimmers and boxers who have maybe these really complex and weird ways of just performing in their normal duties that don't fit perfectly within the regulations that maybe were contemplated for larger sports like the NHL or Major League Baseball. The Olympics are coming up, so it's a great time to discuss athlete visas. You know, there's a lot of international people obviously competing at the Olympics. Most of these people will probably qualify for a non-immigrant visa like the O or the P, and if they're good enough to win a medal at the Olympics, they may even qualify for a green card, which is pretty exciting. We have a few clients going to this year's Olympics, so we're definitely rooting them on. So the actual visa options for athletes, there's a few. So generally the non-immigrant options are O and P visas, and the immigrant options, most people will go for the EB-11. That's the Extraordinary Ability Green Card, and we're briefly going to touch upon the Schedule A Group 2 category also. It's a less common category that's used for green cards, and sometimes people aren't able to apply for it, but we'll briefly touch upon it if we have time, just to mention it and kind of put it in your head of something to think about with potential clients. Hope you like my really cool graphics I have there too. So for O visas, there's a few different categories. Again, this is for people with extraordinary ability. The two categories that apply for athletes are really the O1A, which specifically states athletics, and then there's an O1B category for those in the arts, and we'll get to how maybe some athletes will qualify under the arts and why that would be wise. The other category is the O2 visa, which is for essential support personnel, and the O3 visa for dependents. So there is no work authorization for spouses of O1s who are here on O3s, but at least they can be in the country with their husband or wife while they're performing the events in the U.S. on an O1 visa. So the O1 visa standards with regards to athletes. You can see the O1A in athletics is a very high standard. It requires a level of expertise indicating that the person is one of the small percentage who have risen to the very top of their field. So this is basically, you need someone who's pretty close to the top of their field to qualify for the O1A. It's one of the highest standards there is as far as the non-immigrant athlete visas are concerned. And you also need to demonstrate sustained national or international acclaim. This is up there basically with the EB-11 green card option. So we don't see this petitioned for with a lot of athletes, but on occasion you'll have a reason to go under this classification. The O1B, this is a, sometimes you're able to get your clients down into this category, which is much lower than the O1A in athletics. This only requires distinction, which is just a high level of achievement in the field, evidenced by a degree of skill and recognition above that ordinarily encountered. So, you know, if you have a chess player maybe, or let's say a figure skater, or some of the horse jumpers in the equestrian field are actually able to say, well, more of what we do is really in the arts field. There's elegance to it, and there's just as much art involved really as there is athletic ability. And so when you're preparing petitions, you want to highlight that in things like the reference letters and the support letters, and hopefully in maybe some of the press as well, if they discuss these aspects of the athlete, you can push them down into the O1B category, which is a much lower category as far as what's required in distinction. So the basic O1 visa procedures are up here on the slide. You can see you need to file an I-129 and an I-129O supplement. There are two jurisdictions for this. One is the California Service Center, and one is the Vermont Service Center. Always go to Vermont when possible. So the way you're going to get there is if the athlete will be performing basically under Vermont's jurisdiction, and you can find that jurisdiction on the I-129 instruction form. If they perform events in multiple locations, then the government's going to look to where the petitioner themselves is based. So if the petitioner actually has offices on the West Coast and the East Coast, and there's going to be performances across the country, you should look into trying to get the New York office of the petitioner to file the petition to get it over to Vermont. There's normal processing and premium processing. Premium processing guarantees 15-day adjudication of the petition, and this is often what you're going to use for most athletes. In a lot of cases as well, you may need to even rush the processing faster than that. You can contact premium processing and request an expedite on your case, and they're pretty good about turning things around. I would say use this very sparingly. Officer Doug at USCIS is great, but he probably doesn't want to get a phone call from you every day asking you to expedite your cases. The O1 also requires an advisory opinion or union consultation, so you're going to need to locate the proper union. And when discussing these cases with clients, I'll often say there's three elements to the O1. It's super easy, right? If only. There's a talent. They need to be talented and meet the O1 criteria. There needs to be a petitioner who can be an employer or an agent. And they need to have an event and a contract basically highlighting what they're going to be doing in the United States during their stay. So in O1A or O1B, alien of extraordinary ability, they're going to need to show a few things to show that they're really talented. The first, which will basically meet the criteria, is a major award. So if they win Wimbledon or a U.S. Open or an Olympic gold medal, any of these major awards, they're certainly going to meet the talent criteria of the O1 visa. Most of the clients that will come across your desk are not going to meet this criteria. They're going to have to go for 3 of the supplementary criteria, which are up here on the slide. Just to go through them briefly, they'll need to have a lesser national or international prize or award, membership in an association requiring outstanding achievements, basically press published materials on the athlete, participation as a judge. You don't usually see this a lot in sports, but maybe they've judged something for their sport and you can use that. If they've ever authored an article or some other type of media for their field, you can use that as well. And one you're almost always going to go for is the critical role for distinguished organizations or critical role at events. So if they're participating in all these major athletic competitions, you can definitely highlight that there. And then, of course, if they earn a lot of money, high compensation or salary. And the way to play this is you can go onto the Department of Labor website. We often go to the America's Career Infonet, AC Infonet. And on there, if you put in your state and at least athlete or if they subcategorize the athlete, you can use that as well. But you want to show what the top 10% of athletes earn. And of course, it's going to be a very high number. But if you can show that your athlete on perhaps an hourly basis has earned more than the top 10% of the field, then you're going to get this, hopefully get this high compensation or salary point. And for all these things, proper documentation of the criteria is key. You really need to support everything. A great saying I heard was, assume the officer knows nothing about everything. So, they don't know that the Dodgers are the best team in the world, at least in my opinion. And they don't know who the Lakers are. They don't know what, just how prestigious the Wall Street Journal is if you're including an article from the Wall Street Journal. So, include circulation numbers, include information about the teams or the competitions that the person's competing in. If they win an Olympic award, tell them what an Olympic award is or Olympic gold medal is. Those things, you have to present those for the officer to see. So the petitioner, this can be an employer or an agent. If it's an employer, the foreign national and athlete can only be employed with that petitioner. So this is no big deal if your athlete's basically with a major league sports team. But for some athletes, they're going to be performing at multiple events, and it's just more customary for maybe an agent to file the petition. So in those cases, you're going to probably go with an agent, and you're going to want to include an itinerary showing all the different events that the foreign national is going to perform at. And the regulations say that for the field of entertainment, which I think generally athletes are considered under, you can see the case of Matter of Masters for that one. The foreign national or athlete may add additional performances or engagements during the validity period of the petition without having to amend things. So usually going with an agent is a very good option for most athletes. So what types of agents are there? So there's a few different types. There's an agent performing the function of an employer, where often the agent themselves will be employing the foreign national. You don't see those too often. And the more common type is where a person or company is in business as an agent. And so they're usually filing the petition on behalf of multiple employers. So you'd want to provide contracts with all those employers when possible. And USCIS recently said that an employer themselves can actually file the petition and be acting as an agent for immigration purposes. And so for these matters, you would not only want to provide a contract with each employer, but also provide agency assignment letters. And so this is just a really brief paragraph from all the other employers to the petitioning employer stating that the foreign national is, or they're granting, the petitioner authorization to file this petition on their behalf. It's, again, just a really short letter saying they give permission for the petition employer to file the petition. So the O1 event. So this can be, the O1 visa can be approved for up to 3 years, but right now the adjudication by USCIS is really only approving petitions for the duration of the event. So the longer you can show that the foreign national or the athlete's going to be competing, the longer the visa you're going to be able to get for them. So you want to include a contract or deal memo evidencing what the event is and what the competition is in the United States. This can be difficult though, and so you really want to provide an itinerary that's as long as possible. So include any marketing, training, practice, or promotionals that the athlete's going to do. You know, we did one for a boxer where he had one big fight coming up, and you know, if you only include that he's going to be, you know, fighting for one Saturday at the MGM in Las Vegas, maybe you get a 2-week visa or something. You want to put an itinerary out there that shows he needs to be in Las Vegas to train, to acclimate to the weather, and then, you know, I'm sure there's going to be a lot of promotional things both before and after the fight that he's going to want to be around for to really promote himself and earn money for himself. And then in addition, sometimes if there's a reoccurring event, if the boxer, you know, fights every 6 months and you can show that history and he's really one of the top people in the field, you know, and this goes for any sport as well, you may be able to project those fights out into the future and put anticipated fights into an itinerary to get a longer visa, hopefully up to the full 3-year duration. There can be an issue with gaps. If there's big gaps between things, USCIS may say it's not really part of the same event, and so they could approve the petition for only the first section of the events. Hopefully you can tie everything together and get the full duration and get continued through any gaps. And so that's where, again, you want to include training and practice or other things that the athlete's going to do while they're maybe not actually competing. So advisory and peer opinions. So you do need to get an opinion from the appropriate union or agency. Usually you just kind of want to Google the big sports unions or the governing body of the sport and contact them and reach out to them and say, you know, do you issue advisory opinions? If they say yes, then, you know, be sure to follow up and ask them what they need from you to give you the opinion. They'll often want to see the USCIS forms and the supporting documents to see that the foreign national does really meet the O1 criteria. If a union or advisory union doesn't exist, you can always use a peer consultation, and so that's just going to be a letter from another top expert in the field basically confirming that your client or the athlete is really one of the best in the field and that they meet the O1 criteria. If there's an adverse advisory opinion, you can often still file the petition, but it can be risky, of course. So this is where a union says that the foreign national or athlete doesn't meet the O1 criteria. And so, you know, USCIS has said that it's not governed or it's, you know, doesn't have to abide by what any union says, whether good or bad. So you can remind them of that when filing with an adverse advisory opinion and say, you know, this is not determinative onto whether the athlete really does meet the O1 criteria. So on occasion, you can still move forward with an advisory opinion, but an adverse advisory opinion, but of course that can be risky. So O1 considerations. The regulations say that you can only file an extension of status requesting really 1 year. But if you read the regulations closely, you can only get a 1-year extension for the same event or activity. So if you need to request an extension of status, basically where your client's not going to leave the United States, you can claim that the events or activities of this extension petition are not the same as that in the original petition and request a full 3-year extensions. Remember, the O1 can be granted for up to 3-year periods indefinitely. So if you can claim that the events of the original petition are different than those activities of this next petition, you may be able to request a 3-year extension. I'd say this is kind of 50-50 as far as the cases that have come across our desks, we ask for it and we warn clients about the risks. But if they can't leave the country, sometimes they're willing to see if they get 1 year or 3 years. You can always file these petitions loose or consular process them and just say it's new employment and request the full 3-year O1, but they will have to leave the country to basically kick in the new O1. You always want to prepare your clients for the visa interviews as well. Lately, we've been seeing at some consulates around the world them treating O1 foreign nationals a little bit harsher and even denying some of their visas. I had a client, he wasn't an athlete, but he was denied an entertainment visa because he was told by the Costa Rican consulate that he wasn't Shakira or Ricky Martin. So if your athlete goes in and he's not David Ortiz or Matt Kemp, but he's, USCIS has already said he's an O1 athlete who meets the regulations, you should reach out to the consulate and basically, remind them that they're not supposed to question the approval of an O petition without specific evidence available to DHS at the time they approve the petition. So you can cite that FAM regulation, and hopefully that's going to get them back into the consulate and re-adjudicate the visa application. The O1 can be a good platform for future green card applications as well. You'll probably notice that, again, the regulations for the O1 are very similar to the EB-11 green card application. And so, if someone's maybe on a P and they really want to go for the green card, but they're not quite there yet, you can try to transfer them to an O1, get them on the O1, get them performing on the O1, and then, when they've really blown you out of the water, that's when you submit the green card application, because the O1 regulations are very, very close to the EB-11, but the adjudicatory standards for the EB-11 is just a lot higher. So it may be a good setup, but of course it doesn't guarantee that a green card application is going to get approved. So why apply for an O1 and not a P? For most athletes, you are going to go for the P period. You'll see that the regulations, it's a lower standard. They need to meet less criteria, and you can even get, for individuals, a visa for up to 5 years and not 3. So, there's some consideration to be had. The P1 has a little bit different standards for the reason that the foreign national is coming to the United States. It's a little bit more specific. They need to be performing a specific athletic competition at an internationally recognized level, whereas O1s just need to be continuing work in their area of extraordinary ability. So if maybe everything's not lining up perfectly, the O1 may be better. Also, the O1 is, I guess, pseudo-dual intent. It's not specifically in the regulations, but it's often recognized as a dual intent visa. So if someone does have an immigrant application pending, the O1 may be a bit more of a conservative approach to make sure they're admitted to the United States while that application's pending. So O2 visas, these are for essential support personnel. Basically CIS recognizes that an athlete often has, a posse of people or very, very important essential people that need to be with the athlete to make sure that they're, performing at their highest level. It's important to remember that the O1 must remain intact for the O2 to basically be in lawful status. The O2 is limited to working with the O1. And so you can extend this essential support person status to anybody really that's essential to the O1 athlete. Kind of let your mind go free here, and anybody that's really important to the athlete you can bring in with them. I've heard people have even brought in basically girlfriends or boyfriends because often they're a lot more than that. There may be trip advisors and trip planners or managers of the client somehow or the athlete somehow. They do probably a lot more than just sit around the house and wait for their husband or their boyfriend or girlfriend to come home from competing. And so the criteria they have to meet are they need to have critical skills and experience with the O1 athlete, not of general nature, and possessed by a U.S. worker. Typically, you can meet this just by basically a letter from the athlete describing the essential nature of that the O2 personnel. It does require a separate petition, so you're going to be filing a separate I-129 and O supplement for the O2, and you also, of course, need to include the supporting documents to meet the standard for the O2. It also requires an advisory opinion or peer consultation, which we've discussed. And one thing to note is that the California Service Center is a bit harsher than the Vermont Service Center, again, on adjudication of the O2 visas, similar to the O1. So, you know, we do see it with family members where a lot of the time these family members really have been coaches or managers to their son or daughter. Of course, you know, Tiger Woods' dad was extremely important to raising him as one of the best golf players of all time. And so, you know, CSCs sometimes denied cases just because there's a family relationship involved. Anytime you can provide third-party evidence, maybe there's press on the mother or father who helped coach their son or daughter. If you can provide that third-party evidence, that's going to be a lot more compelling than just evidence like a letter from the athlete themselves describing the essential nature and essential, basically, purpose of their father or mother coming into the country to help them. So P visas, these are the visas that are most often going to be used for athletes. Again, for individuals, you can request a 5-year visa, and for teams or groups, you can request a 1-year visa. So, you know, this obviously is more advantageous than the O. You're going to hopefully get an initial 2-year period if you apply for the P instead of the O. There's the COMPETE Act, which came out in 2006 for amateur athletes and coaches. It's just a 2-page memo you can find online generally from CIS, which covers this, and the criteria are on there, and we'll go through them, but that's a quick read if you want to go to it for potential amateur athletes and coaches. For the P, similar to the O, you're filing an I-129 and P supplement, and again, you're going to either the California Service Center or the Vermont Service Center, which have jurisdiction over these cases. If you're dealing with major league sports, if you're fortunate enough to do that, then you're lucky enough to also go directly to the Vermont Service Center. We're going to touch a little bit more on major league sports later, but you know, these sports, everything should be filed with the Vermont Service Center. So the P1 visa standard, this only requires international recognition, which is having a high level of achievement in the field, evidenced by a degree of skill and recognition substantially above that ordinarily encountered. So, you know, this achievement needs to be renowned, leading, or well-known in more than one country. So obviously, international recognition is much lower than the O1 visa criteria, at least O1A criteria, which requires athletes to be someone in the top few percentages of their field. This is, you know, a large reason why, aside from other benefits, that most athletes are in the United States on a P1 visa and not an O1A. You'll also need to show that the athlete is performing at an internationally recognized level. So P1 visa criteria. For individuals and teams, you need to show 2 of the following. Specifically, they need to have participated in a prior season with a U.S. Major League Sports team. Obviously, this is probably mostly for individuals, but if they've done that, you're going to meet this criteria. One additional thing to mention, you know, if they've won a major sports award, you can definitely use that with the P visa criteria as well. Have they participated in international competitions with a national team? So if they're, you know, playing in a big national, let's say Hungarian soccer league, you can then, you know, get that criteria. Have they participated in a prior season for a U.S. college or intercollegiate competition? You're going to get that point. Letter from an official major U.S. sports league or official of governing body of the sport. You'll find that your clients can often get these letters, and a lot of the sports leagues or the governing bodies are quite willing to write them. So again, feel free to reach out to those bodies, and this could be an easy point for your client to get. You can use also a statement from a member of the sports media or an expert in the field. Again, most people can get a letter from some other very talented coach or athlete. Maybe even they have a sports media journalist they can get a letter from just on how acclaimed and internationally acclaimed they are in the field. You can also use the proof of that the athletes ranked in the field to get one of these criteria. And finally, it's the significant honor or award. So if you meet two of those, you're going to have the talent portion of the P1 visa criteria down. Again, you only need 2 for the P, not 3 like the O1 visa. And as you can see, a lot of the athletes you encounter will probably meet these regulations. So the COMPETE Act specifically touches on minor league athletes and coaches. Again, this came out in 2006. A quick Google of 2006 COMPETE Act will pull this up for you. So for professional athletes employed by a minor league team that's affiliated with major professional sports association, so any of those athletes that are in that category, they can get a P1. Most people you'll probably see fall into the second category, which is coaches and athletes performing with teams in the U.S. that are part of an international league of 15 or more amateur sports teams. So potentially soccer, hockey. Those foreign leagues must operate at the highest amateur level. Participation in that league must render them ineligible to basically participate at a U.S. college under the NCAA rules. And a significant number of those players must be drafted by major league or minor league U.S. affiliates. And finally, the regulations of the COMPETE Act also specifically state that amateur and professional, it says theatrical ice skaters, I think, are able to basically qualify for the Ps. And this is a lot of it's due to just basically hockey players being able to come into the country under the COMPETE Act. So the P1 visa, similar to the O, requires a petitioner, and again, you can have an employer or an agent be the petitioner, similar to the O1. So we've kind of already gone over those. Some hiccups here are you'll see that sometimes the regulations don't fit in perfectly, again, with the athletes. The agent's probably not going to be the actual employer or the beneficiary. Maybe they won't represent both the employer and the beneficiary. So, I recently got a P1 for a swimmer who she goes out and competes at these open competitions. So the agent doesn't represent the employer. Nobody represents the employer as far as visa is concerned. So, the swimmer didn't fit into that category either. Sometimes you're just kind of citing to the regulations that, this isn't a perfect fit, but as far as contracts are concerned, which we'll get to, this is the standard in this sport. So you want to highlight that, the regulations are basically, you're trying to fit a square peg into a round hole here by saying that, the regulations don't perfectly encompass this sport. Basically, please accept the contracts and itineraries that have already been provided. Finally, if you can get a sponsoring organization that's willing to, confirm in a contract that they're going to assume the responsibility for the accuracy and the terms and conditions of the petition, then they can file the petition as well. So P1 visa contracts, that's just kind of touching upon this. The regulations require a contract with a major U.S. sports league, which, if your client has that, great, or a contract in an individual sport commensurate with international recognition in that sport. So when you're filing with an agent, they'll probably have an agent contract with the athlete, but then you're also going to need to typically provide at least contracts with all the different employers that they're going to use. So if your boxer's got an agent or manager, they'll have an agreement with them, and then they'll probably have an agreement with Oscar de la Hoya or Don King for each upcoming fight that they're going to participate in. Again, if you can't get those contracts with each individual employer, you definitely want to put forward an itinerary that's going to highlight exactly where the foreign national or the athlete's going to be and where they're going to be competing. So P1 visa issues. The duration of the visa is often tied to the event. Again, this is similar to the O1, where USCIS is often only approving the visa for the duration of the competitions or the seasons. So the longer the itinerary you can provide, the longer the visa the foreign national is going to get. Hopefully you can, if it's a seasonal competition, you can show that every season these have gone on, and you can extrapolate prior seasons future seasons and include an itinerary like that. Of course, highlight that all of those things are subject to change and may be based on history of these seasons, which have gone on for 10 or 12 years, whatever it is. Highlight those things, and then you're more likely to get hopefully a 5-year visa or a visa of a long duration. So for Major League U.S. sports, again, the Vermont Service Center has exclusive jurisdiction over this. Specifically, the Major League sports have been recognized as the NHL, Major League Baseball, and the NFL. You can, of course, see that there's a few missing here. I think that Steve Laddick, who's with Barry Appelman, is actually petitioning to VSC to see if they will they'll cover golf. Lacrosse used to be on there, and it's no longer on that list. So this is kind of a fluid field as far as what's considered a major league sport. So you may want to even reach out to Vermont Service Center if you think your sport should be considered major. Maybe they'll include it in their list, and then you get the joy of filing with Vermont instead of California. For traded professional athletes on a P, their employment authorized automatically extends to their traded club or team for 30 days after the acquisition. And so, but you must file the I-129 and the P petition within 30 days of the trade. Otherwise, that's going to lapse, and they're potentially going to be out of status. One thing to note is a small wrinkle in this is trades between a Canadian team and a U.S. team. Of course, the Canadian club, hopefully, their athlete that's coming over to their team is going to be able to perform rather quickly, but you're going to have to submit a brand new petition to Vermont Service Center basically to get that case approved as soon as possible, because someone coming from Canada obviously is not in P1 status. Substitution of beneficiaries. So if you're petitioning for a big team to come in and maybe a player or two gets sick, you can submit a letter to the consulate or port of entry along with the approval notice, basically highlighting that beneficiary's qualifications for the P, and of course giving them the approval notice to show that this team's allowed to come in, and they need to substitute these beneficiaries to come in and compete at an event. Visa reciprocity. So some countries have got different visa periods that are given to athlete classifications. So Brazil, for example, you're only going to get a 3-month visa. So when a client comes in, even though their approval notice is maybe for a 5-year period, the CBP officer may still only admit them for for the duration of the visa, which is a mistake. And so if the client comes in and they don't notice that they've only been admitted for 3 months, then they could easily fall out of status and begin accruing unlawful presence. So aside from having your client always email you the visa and the I-94, if they can take a letter from you, or just be, of course, alerted to the fact that they should be admitted for the duration of the approval notice, then hopefully there's no issues coming in, and they won't fall out of status if they don't notice that the CBP officer has shortchanged them. So they also need to demonstrate with the P non-immigrant intent. This is one differentiation with the O1 as well. So when you go and apply for the visa at a consulate around the world, they often want to take with them 214B documents to show they don't intend to immigrate to the United States. Again, the O1 doesn't have that. This doesn't come up a whole lot with athletes, but if for some reason your client may be more of a suspicious character and been here a really, really long time, you may want to make sure they have with them some documentation to show they're going to return home after coming to perform in their U.S. events. Expanding the meaning of athlete. So how to get someone down into a P1 rather than an O, just to get them out of that, maybe that O1A, or someone maybe who you don't think is normally a P1. So like chess players and poker players, again, if you can, chess used to be in the Olympics, and so it's more than just a game. There's a lot of strategy involved. And the fact it was in the Olympics shows that, at least to some extent, this was considered an athletic sport at some time. And so the same thing can probably be said of poker and other sports as well. So P1S, so this is the essential support personnel for the P1 visa. So the regulations say that the P1S can actually be only admitted for a period up to 1 year, but you'll find in practice that they actually are often approved for the full duration of the P1 athlete. So even though you may see 1 year in the regs, the actual athlete, the P1S support personnel, is going to most likely be admitted, and you should request the duration of the visa to be the full duration of the P1 athlete. Be wary of jurisdiction issues. Again, this is the same thing as the O2 personnel. California Service Center, if they see family ties, it may really prejudice the essentiality of the P1S personnel. The Vermont Service Center, often if you simply show someone is somehow tied to the P1 athlete, then others can get the P1S. You know, a great question to always ask someone that comes into your office thinking about or tied to an athletic event is there anyone else on a P1 or anyone else on an O1? Rather than applying for that same person's P1 or O1 visa, maybe you can get them a P1S or get them an O2. It can make your life a lot easier. There's less documentation, less likelihood of an RFE often, a request for evidence, and things can go a lot smoother. Again, always remember that the P1 must remain intact. What happens if the P1 holder goes home or they get a green card? Well, then technically the P1S is no longer valid. They don't have anything to cling on to anymore. So you're going to have to try to apply for that own person's P1 or O1 visa. And so that's where maybe, you used to say they were just essential, and now you need to kind of fluff up their credentials to say, well, they really are these leading people, and either an athlete an athlete who's internationally renowned for P1s, or for the O1 they're someone of extraordinary ability. So that can be a challenge, but it's gonna have to be what you're gonna have to do if the visa holder, basically the primary visa holder, leaves the country. Oops. So the standard criteria for the P1S, again, you have to show that they're a highly skilled, essential person who's integral part of the performance for P1. So again, it's very similar to the O2. You just want to show the essentiality of the person and highlight the experience and the background they have together. Again, typically a letter from the P1 athlete is going to be sufficient. Again, you need a labor organization opinion to be filed with P1S as well. The statement describing the skills and relationships is going to be critical. And, of course, include a contract highlighting how the P1S person's going to be performing with the principal P1 athlete. So there's also some B1 options for athletes. This is for athletes typically coming in for very brief stints. Of course, the B1's typically only valid for 6 months at a time, and there's a few conditions. The first is that the athlete receive no salary other than prize money. And so, the regulations actually specifically state that this is, for golfers and auto racers, and that's not exhaustive, but those are you want to kind of analogize your athlete or your sport to those types of athletes. So this swimmer I just got a visa for, she definitely could have come in under this B1 regulation, but she wants to perform at a lot of ongoing competitions. So, when she's wanting to be here for more than just 6 months and want to train and participate in a lot of competitions, that's where we start looking at a P1 over just this B1 option. An alternative to that is for athletes and team members who are foreign, basically part of a foreign-based team who want to compete with another sports team. And so you can see the criteria there. They have to be a foreign athlete, and the foreign sports team have their principal place of business or activity overseas. They're coming into the the income of the foreign-based team and the salary of its players are principally accrued from a foreign country, and the foreign-based sports team is a member of an international sports league, or the sporting activities involved have an international dimension. So you're going to want to meet those 3 criteria for this type of a B1. And then finally, there's also a specific provision for hockey players basically trying out for teams here. They can't sign a contract with the hockey team, and they can only be compensated for incidentals. But you know, once they basically prove themselves and they're on the team, they're probably going to sign a contract. That's when you need to apply for a P1 or an O1 for that athlete. So the green card options. This is what everybody wants at the end of the day. So this is you know, for the best of the best. Again, the O1 is a nice stepping stone, but it doesn't mean the person automatically qualifies for the EB1. And so this requires a level of expertise indicating that the individual is one of the small percentage who have risen to the very top of their field. Now again, so I said this on the O1, the adjudicatory standard right now for the EB11 is extremely high. Basically, even though the criteria are the same, you'll see as we go on here that USCIS is basically denying a lot of these petitions, although maybe someone has an O1 visa. And so this can be self-petitioned or employer-sponsored. For those weaker cases, you may want to put an employer behind it. So if you have a big major league sports team that's willing to sponsor the thing, and maybe just a more mediocre athlete, it's going to behoove you to see if the major league sports team will file this petition rather than the athletes petitioning themselves, because you know it's going to kind of show CIS just how valued the foreign athlete is and that someone's willing to sponsor them. So aliens of extraordinary ability, EB11, again, you're showing, similar to the O1, sustained national or international acclaim, and that achievements have been recognized in the field of expertise. So again, similar to the O1. And also like the O1, evidence includes that one-time achievement. So if you have a client who comes back from the Olympics and they win, you know, the gold medal, you're going to be able to meet all these criteria just by, you know, photocopying the gold medal and putting evidence of what a gold medal is behind that achievement. This is going to make your life very easy. If they don't have that, they're going to need at least 3 out of the following 10 criteria. And you know, all of these don't necessarily apply to athletes again, but that's what we have to work with. So you know, the lesser national or international prizes or awards, membership in associations, that has quite a stringent criteria for membership. You often want to include the bylaws of the membership to show what it takes for an athlete to get into that association. If it's just paying money or filling out an application, that's not going to do it. You need to show that, you know, to get in this home run club, you need to hit 500 home runs over your career. Then that's going to be a great membership or association that you become involved with. Publish materials in mainstream media. Of course, be sure to include the circulation numbers and the esteemed nature and background of the publication. Again, you want to assume that CIS doesn't know what this publication is. Also, you know, participation as judge of the work of others. So include information about the event that the sport or the athlete's judging. You know, include information about the other judges, showing if they're big names that, well, this is who my client's sitting alongside. Clearly, they're an athlete of extraordinary ability if they're sitting next to these other big names. Also include original contributions of major significance. So if they've done something for the sport, let's say your surfer invented a new surf move, or your snowboarder invented a new snowboard move. That may be an original contribution of major significance if all the other athletes begin doing this move. Authorship of scholarly books or articles. So you know, if they wrote a book or an article on something, certainly use that. Artistic exhibition or showcases. You may be able to use this for something like, you know, Olympic skaters or figure skaters who are showcasing their talents at big artistic exhibitions. Of course, the critical or leading role for big events, you're almost always going to go for that one. High compensation, you know, CIS almost expects to see this with athletes. If you're saying you're one of the best athletes in the world, then you're probably going to be getting paid a lot of money. So they may be almost expecting to see this criteria when you're submitting an EB-11 application. So I'd say be prepared to show this. Commercial success, again, doesn't necessarily apply to athletes unless maybe you can show how well their jerseys have done, or, you know, for certain big name athletes, you know, maybe attendance goes up at the stadium because they joined a team, something like that. Tim Tebow's, you know, was the #1 selling jersey last year. You know, that's some commercial success that was directly, basically attributable to Tim Tebow. So the EB-11 process, you're filing an I-140 immigrant visa petition. You can premium process this application, and clients always ask, is there a higher risk of RFE, a request for evidence here? You know, you're forcing USCIS to adjudicate a green card application in 15 days. Sometimes they don't like to do that. So when you're considering premium processing application, unless a client has a very good reason to do so, and they're very, you know, they blow you out of the water, maybe they're that Olympic gold medalist, you may just want to put the thing in for regular processing. Also, you know, again, you're filing with the Texas Service Center or the Nebraska Service Center, no longer CSC or VSC, so make sure it goes to the appropriate service center. You used to be able to e-file the applications and everything would go to the Texas Service Center, which has, I think, historically been a little bit more favorable than the Nebraska Service Center. But recently that stopped happening. When you e-file an application now, everything's being routed to the appropriate service center. So if you're supposed to go to TSC, that's what the e-filing receipt's going to say. If you're supposed to go to NSC, that's what the receipt filing is going to say. So basically, just go where you're supposed to go now, and don't try to get to the more favorable service center as you may have used to in the past. The second step, which can be done concurrently with the I-140 or separately, is the actual green card application, the I-485. And so do you want to file concurrently or separately? The benefit, of course, is maybe the green card comes a lot faster if you file both things together. The problem is if the I-140 is denied, then you've just wasted a bunch of money, maybe attorney's fees as well as government filing fees, you know, submitting these adjustment of status applications. So it's something to consider with your clients. For those weaker applications, you're definitely going to want to bifurcate the two and just go with the I-140 first, unless there's a compelling reason why maybe the foreign national doesn't want to extend a P or O1 visa, and you can just get them an employment authorization document after filing the adjustment of status application. So some adjudication issues. USCIS is very unpredictable right now. They have an extremely subjective standard as to how they're looking at all the evidence and as to how they're looking at whether the athlete really meets the criteria of the EB-11 athlete visa. And so another consideration is they must be continuing to work in the field of extraordinary ability. Lee v. INS is a great case that demonstrates this. The person was really a top player in the league, and actually that was acknowledged, but they had since gone on to become a coach, and their record as a coach and their claim as a coach really wasn't that great. It wasn't extraordinary. And so they weren't going to be extraordinary in their field and continuing to basically benefit the U.S. by being a coach necessarily, or an extraordinary coach. And basically that's what CIS picked on, and it was upheld, was, you know, make sure that you have to strike while the iron's hot here for some people. And so if they're thinking about changing careers and they're really, really good, maybe you want to file them in whatever category they're in now before they become maybe a coach or a teacher in that sport. Muni v. INS is kind of a classic athlete case I want to bring up. It was this great defensive hockey player. He won 3 Stanley Cup trophies. He had one of the best plus-minus ratios on the team in the NHL. He was ranked top ranked hitting defenseman, and he made $400,000 a year, which, you know, that sounds great to a lot of us, but to CIS, that was just the average salary. This was denied by CIS and affirmed on appeal, but eventually the district court overturned this case. You know, they highlighted all these things and, you know, basically said, are you crazy? You know, he has all these excellent, you know, all these excellent criteria met. There's no way he's not really one of the best out there. So, you know, that's a great case to look at and see just how harsh USCIS can be when they're adjudicating these things, because, you know, they often, they'll get stuck in their ways, and any way they're going to be able to deny something, they may do it. In Bulletini, it's another popular case that's often cited in request for evidence responses. That case said that if the beneficiary meets 3 of the criteria, the burden is going to shift to the government to show specific and substantiated reasons why the beneficiary is not extraordinary. So this was a great case. Everybody loves to cite it to say, well, now it's your job to say why they're not extraordinary. But CIS doesn't really care. They don't always listen to the district court opinions as far as you know, what the judges there are saying. So it's a great case. Use it and cite it, but don't rely on it. So the big monumental case in 2010 was Kazarian. And so it was wonderful because it said that an adjudicator may not implement novel requirements not in the regulations. So, you know, adjudicators would often say, you know, this award is great, but, you know, it doesn't require outstanding achievement, or they throw in all this other language that's not really in the regulations. And so, you know, Kazarian's great because now you have this case to say, well, you're going outside the bounds of the regulations. Here's the specific wording of the regulations, and my client clearly meets this criteria. So it's good for that purpose. The problem is it implemented this final merits determination, which basically now the adjudicator has a lot of subjective discretion to determine whether someone has sustained national or international acclaim and whether someone is in the small percentage who have risen to the very top of their field of endeavor. So those are the 2 basic criteria in the final merits determination, and you really have to address these when you're preparing an EB-11 case. There's a good AILA Nebraska Service Center minutes out there where it says that basically adjudicators are trained to look for the top 15 to 20% of the field for these cases. In actual practice, that doesn't seem to be the case. It seems like they're looking for the top few percentages, you know, top 5, top 3%. But this is something to maybe put out there if you're responding to a request for evidence. You know, it's a Hail Mary. This isn't, you know, precedent by any means, but at least it's something. I would take a look at the RFE template released by USCIS on January 2010. So check that out. It's a great way to kind of help prepare a case and to look at what USCIS is looking for as far as when you're preparing a case and ways that they're going to maybe submit an RFE to you and that you're going to have to respond to. Finally, just to mention EB2 Schedule A Group 2 quickly, this visa classification is sort of a combination of a perm with the extraordinary ability concept. The reason why it's useful is it only requires exceptional ability. It doesn't require extraordinary ability. It's definitely a lower standard, at least as far as the regulations go. In practice, though, we really see that USCIS is almost adjudicating these as though they're green card EB-11 petitions. You'll see that their requests for evidence will often miscite the regulations, and they're citing EB-11 criteria in these. And so, when you receive an RFE, if you're doing a Schedule A Group 2, be sure you look at the language they're citing. And if they're citing the wrong regulations or putting in the wrong standard, you may want to mention that in the RFE response just to be sure that you're highlighting the lower standard that is Schedule A Group 2. It has to be an employer-sponsored petition. They must pay the prevailing wage for the position, which may be an issue for some athletes. And then I'll just refer to you the USCIS and Department of Labor regulations as far as what those criteria are. They're sort of a mishmash between the O1 and EB11 criteria we've covered today, but go through those. Hopefully your athlete will meet these. Again, if your athlete's not quite extraordinary and if they don't meet the EB11 regulations, look at the EB2 Schedule A Group 2. Could be a good alternative option for them. So now I think we're going to open it up to some questions you may have. And so I guess fire away. So Leslie asked, will we be providing a copy of our presentation, which we will. You'll get an email after this presentation with our PowerPoints in there, so look out for that. And always feel free to reach out to us, shoot me an email or give me a call if you have any follow-up questions or specific questions on cases. I'd be happy to go over things and answer any questions that you may have. Well, thanks everyone for coming in. Again, if you have any questions, shoot me an email or give me a call. Hope you enjoyed the webinar. Again, you can check our website for additional webinars. Go to our Facebook page, and you can always find updates there if you like. And thanks for joining us.